Everybody's admitted. Okay, the meeting is being live streamed. Okay, I just want to give a few moments for those in the public to join us. Want to welcome people from the public to this meeting of the Subcommittee on Government Operations. Our regular meeting time will be 11 o'clock, and we will do our very, very best to be on time the next time. We apologize for the delay today. Hold on 1 second. All right, we have 3 bills before us. Just in light of the delay, I'm going to take the one with a significant amendment last to make sure everybody has gotten in. So we'll begin with House Bill 163. This is legislation that was before us last year. With one exception, if we voted it out, passed the House. It is an emergency bill this time, and Lindsay will provide us with the details.
This bill modifies the definition of distribution list as it applies to the denial of inspection of distribution lists under the Public Information Act to exclude a list of recipients of specified notices from the State Highway Administration or Maryland Transit Administration relating to environmental and engineering studies on private property under the state's eminent domain statute. A custodian must allow inspection of such a notice or a list of recipients of such a notice only on receipt of a written application and a statement signed under oath that the notice or list is not intended to be used for commercial solicitation. The bill further specifies that a definition of sociological information adopted under rules or regulations by an official custodian may not include above specified notices or recipient lists. And finally, the bill requires a custodian to deny inspection of only the part of a distribution list that identifies an individual's physical address, email address, or telephone number rather than the full distribution list. As Delegate Rosenberg mentioned, this bill this year is an emergency bill. Last year, an identical bill was passed unanimously in the House, but that one was not an emergency bill. So that is the difference between this year's bill and last year's. Last year's bill was House Bill 272. And there is no fiscal impact on this bill.
Okay, is there any discussion? As I said, this is the same bill as last year's, except it is now an emergency bill.
Question.
Delegate Kipke.
Thank you, Mr. Chairman. I guess this might be for staff. The question, so I've always been concerned that this list could be used for commercial purposes, and there is an amendment that says that I believe we adopted an amendment last year that would preclude it from being used for commercial purposes. However, I'm curious, if someone does use it for commercial purposes, are there any penalties or can anything come of that?
The person is required to sign a statement under oath that they intend to use it for commercial purposes. I'm not sure offhand what the penalty would be for violating that oath. I'd have to look into that. It's a penalty of perjury, so you could be charged with perjury, I guess.
I'm just thinking about, for example, if in an eminent domain situation, such as what's going on in Montgomery County, which I think is the genesis for this, lawyers perhaps could get a hold of this list and then, try to target people to solicit, lawsuits basically against the state for, so that's my concern. So I just want to throw it out there. Thank you.
Well, are you satisfied with the response from council or not?
Yeah, I mean, it sounds good. I just want to, if it's before we vote on the bill, I would just like to make sure we have a clear understanding of what the penalty would be for that individual. I want to make sure there's actually something that can be done to them.
Sure.
Yeah, thank you.
All right, so if we move forward on the bill, council will notify the subcommittee as to what the penalty is. So we'll know that before the voting session Friday afternoon.
Right. I will note that at least with the specific question with regard to lawyers, I would assume that the State Board of Law Examiners would consider that unprofessional conduct that they could discipline an attorney for if they had signed an oath saying that they weren't going to use it for commercial purposes and then did. But that would just be specifically with regard to an attorney doing it.
Okay. Is there any further discussion? Certainly, Delegate Zliga.
Thank you. So, I'm going on a little bit further with what Delegate Kipke said. Certainly lawyers, have a penalty that Lindsay just discussed, but what about a business, a realtor, real estate company that again is trying to get into the middle of an eminent domain issue? So, I would like to know what kind of penalty, if any, there is. But the other question I have, I looked at the Department of Transportation's testimony, and they mentioned something about an opt-out. So, I'd like the sponsor of the bill to consider some kind of opt-out for people whose names might be on this list, so that, citizens, property owners, whomever it is, business can say, no. I thought that was a good point. And hopefully, Delegate Carr, that's something that you could look at including in the bill.
Delegate Carr is not on my
Here.
screen. Oh, I'm sorry.
Yeah, can you hear me?
Yes, my mistake.
Yeah.
Oh, sorry.
Yeah.
Yes.
So yeah, thank you, Mr. Chairman. Thank you, Delegate, for that great question. I remember that being asked and answered last year, that these are property records. They're already public information. You can go to SStat, real property information page, and look at your own property, anyone's property in the state, and it's public information. The identifier of the property, the mailing address of the property owner, the name of the property owner. So that's the information that's in notices like this. So it's not something that's not already public information. So that's what I remember of this being sort of asked and answered last year.
Although what you're asking for is a distribution list. So who's on the list? So anybody could actually, I use that SStat list quite often in my other job. And I think it's very handy, but you're asking MDOT, specifically MDOT is, I think who you're asking them to provide you with a list of people that they've contacted. And I think MDOT is reasonably saying, if you want this list, we should at least be able to ask people if they don't want their information shared. Because again, it is, you can go on SStat's site and look up any property ownership that you want to, but I think this is a reasonable request on their part. It would be to protect property owners' identity from their information being released to others, should they want that.
Thank you, Delegate, for that great question. Yeah, I think this was asked and answered last year when we had extensive discussion of the bill. So these are letters. We even had the sample letter. As MDOT sends a letter to Jane Smith, we're gonna, you might see a surveyor in your property taking soil samples. This is a letter required in the statute in the real property article for eminent domain. And so it's not a distribution. It's only MDOT is saying that a letter like that is a distribution list. I don't think that is a distribution list, in the sense that in the bill we passed in 2018 that they're using as the reason why they don't have to show copies of letters like that. So this bill clarifies that information is not a distribution list.
And if I heard correctly, this list is of information that is already public record, is it not? So what we are asking Department of Transportation to do is facilitate the access to those names, because they are creating a list as opposed to an individual having to go through and find the names themselves.
Well, it may or may not be public, the person whom the Department of Transportation may be in negotiations for to purchase their property is, you may or may not be able to find that information. So I don't think it's, quote, public information. That's why this bill's before us, is because, this bill aims at making this information obtainable, I guess, by, if you can't use it for business purposes and lawyers can't use it, I'm assuming it's so politicians or homeowners associations or, other people can access that specific list of people that have been contacted by MDOT. So again, I think allowing those folks to say, no, I don't want you sharing my information is reasonable protection of their private information.
Thank you, Delegate. So yeah, what happened in my district was, MDOT started sending these letters to people, and a municipality in my district was concerned, and we wanted to know the footprint of who's receiving these letters, the footprint of this project for eminent domain. And MDOT hid behind a 2018 law that we passed that was intended to protect, municipal county residents from spammers, from harvesting like a newsletter email list from spamming. So that was the purpose of that 2018 law, but MDOT's hiding behind that, calling letters, they're sending out as a distribution list, which it is not. And before 2018, we're just resetting the clock. So before 2018, this is information that MDOT, would have freely shared, and they often did freely share if a legislator or a member of the public said, I'm doing a Public Information Act request. I'd like to know, see letters that you've sent out for eminent domain in a certain area for a certain project. They routinely shared it. They always shared it. It was never an issue. We never ran into these hypothetical problems or situations. It's only since this 2018 law that was meant to protect, municipalities and counties and their residents from spammers that MDOT began hiding behind that as an excuse to not reveal the footprint of their project.
And who can obtain this information? Can anyone?
So this would be, available
Under this
under a
bill?
Public Information Act request. Someone could obtain a letter that is sent to a property owner saying, we're going to send a surveyor to your land as the first step of eminent domain. And MDOT could not claim, that is a distribution list or that is sociological information. They couldn't deny a MPIA request, but someone would have to sign an affidavit saying they're not using that information for commercial purposes.
And you're saying that, and not disputing that this was the law before, there was no doubt that this was the law prior to 2018.
This was the law for decades. So only in 2018, it was only 2019 that MDOT began hiding behind that law that we passed for a whole different purpose, saying that they were required to not share those letters that revealed the footprint of their project.
But I still think that the privacy issue, regardless of whether it was or wasn't done before, the individual property owner should have the right to say, I don't want you sharing this information. Why wouldn't we give that property owner that option? Especially if you're in negotiations for property sale. Again, I'm not protecting MDOT here. I'm protecting the property owner who could say, this is my negotiations with MDOT. I'd like you to not share that. They could, take the letter and give it to the paper. There's options for the homeowner, the property owner, but, I still think that's a valid point in allowing a person to say, no, I don't want this private negotiations I'm in to be shared.
Yeah, thank you, Delegate. So again, I think this was asked and answered last year when we, debated this bill and passed it unanimously in the committee and in the House of Delegates. So I think we resolved that concern. These are, this is not a negotiation. It's simply a letter that MDOT sends out as the first step of an eminent domain process. And for decades, this information was always available through an MPIA request. There were never any issues. It was only recently that MDOT began, hiding behind a 2018 law, claiming that a letter sent to a property owner is somehow a distribution list and needs to be denied and can't be shared as public information.
Yeah, that we're still not circling back to. So you're saying you don't think that people should be able to opt out?
Yeah, I think we asked and answered this last year. And, again, this is the type of information that's always been available through a PIA request that was never problematic. So, it's the only issue is that, MDOT somehow claiming that a letter, is a distribution list, which it is not. So we're clarifying in this bill that a letter like that or a group of letters like that is not a distribution list.
There are three members who have their hands raised. Is it to speak on this issue? Yes, okay, Delegate Kaiser.
Thank you, Mr. Chairman, and thank you, everyone. I do have three questions, and I do think there's I appreciate Delegate Shalega's concern, and I think there's a way around it that would be different from an opt-out. But I first want to ask the question of Delegate Carr or Lindsay. When I look at the fiscal note, it says, one second. It says the bill requires a custodian to deny inspection of only the part of the distribution list that identifies an individual's physical address, email address, or telephone number. So I thought, in fact, we're not providing that information in that form. So can someone clarify the fiscal note with what's already been said?
Sponsor? Or staff?
Right. Yeah. So Lindsay can correct me, but I'll try to take a stab at it. So the bill says that notices like these that are sent out by MDOT as the first step of eminent domain are not a distribution list. The bill also says that a custodian can redact. If someone requests information that's in a distribution list, they would only withhold the part of the distribution list that includes that sensitive information. So if you had a distribution list that had,
so if that
name,
part's being
address, email
excluded,
address,
then no one's name and address is being shared.
well, I would refer to Lindsay.
So it's two different pieces. One is the definition of distribution list. So these letters wouldn't fall under the definition of distribution list.
Okay.
Things that remain as distribution lists, those, the portion of that distribution list that identifies the person's name, physical address, and email address can be redacted out.
Okay. And then I have, thank you both. So that makes sense. I have two other, one comment and then one question. The reference to the fact that all of this is available in SDAT anyway, and that I could look up you, Delegate Carr or Delegate Shalega, and find out, I could, if I had your address, or if I could just knew the addresses on the given streets, I could type it in, I could find out who owns it, who they bought it from, how square feet, how much it costs, all of that. But it's also true that using the SDAT to say that it's equally available isn't quite the same, because you kind of have to type in one person at a time.
Mhm.
So that's not quite accurate. But I want to get at the point of your bill, Delegate Carr, because I think there's another solution to it. Are you specifically concerned that when MDOT claims to send a letter and you want to confirm that it's actually been sent, are you really just trying to confirm that it was sent to everyone on A Street, B Court, C Avenue, and D Way? I mean, is that all you really want to know? Because in that sense, then you wouldn't need anyone's name or address. are you just trying to confirm that the letter was sent at all and that people got notice?
So I think what my goal is to try to, reset the clock back to the way things used to when MDOT used to freely share information like this. Tell me, reveal to me the footprint of this project you're working on, which properties, are you eyeing up for eminent domain, and which properties did you send letters to for your project? So, and it doesn't have to include the person's name, but it has to in some way identify, the property. It could be the property address, could be the, account ID from SDAT. That's, they would always freely share that information. It's only recently that they began hiding behind.
I understand. I've heard
too
you
long.
say that to Delegate Shalega a few times. I'm just trying to understand, would your goal still be solved by simply knowing everyone on all 5 streets got it? And if it's about eminent domain, which may only impact 4 or 5 houses, to just know that that only the people directly impacted received. And then maybe it is really just 5 houses, and then we could all look it up and it's public. But would it otherwise be okay to just say everyone on these 5 or 10 streets received it?
That would be better than what MDOT is doing now, but ideally we want them to do what they always did, which is just, reveal which properties received a letter like this.
Okay, thank you.
Delegate Chisholm.
Thank you, Mr. Chairman. Just a real quick point of clarification and then my question. When you're on SDOT, you can actually just put the county and the road and it'll give you every name on the road, so you can look it up that way.
That's
I understand that you can't use it. It's prohibited from commercial use. But could the press get it? And then the press then print all of the names that are could it be used in that fashion is my concern. Then somebody feels like, I did get a letter from Maryland Department of Transportation, but now all of a sudden the Montgomery County Times or the Sun is printing my name or because then it's kind of it's a freedom of a press, but also we're kind of violating their privacy, would be my concern.
Yes, for the question. So yeah, under this bill, letters that MDOT sends out, as that first step of eminent domain would be public information that anyone could request as long as they're not using it for commercial purposes, just like it always was until recently when that law was invoked.
So the press could essentially publish it, because it's not technically for commercial use.
So anyone could request that information under the PIA as long as they're not using it for commercial purposes.
Okay. Thank you, Delegate.
Delegate Johnson.
Thank you, Mr. Chairman, and thank you, Delegate Carr. So anybody can go in and request a PIA and get this information. So who are the only ones that is exempting giving this information out? This bill is MDOT, correct?
So these notices, these letters are sent out by MDOT. They're the only entity that sends out these eminent domain type of letters. So they would be the recipient of a PIA request for these letters, and they wouldn't be able to, they couldn't be used for commercial purposes, but they would be requestable, and MDOT would have to provide them. They couldn't claim that they're distribution lists or sociological information.
So my question is, for clarity, anybody can go in and do a PIA and get this information, but the only ones that are not required to give out the information would be MDOT.
So MDOT is the one that has the information. This is a type of letter or notice that is only sent out by MDOT. So MDOT would be the recipient, the only recipient of a PIA request to say, show me the letters that you sent out to property owners as the first step of eminent domain.
But you say all this is public information anyways.
So yeah, property information is public information. Anyone's property can be looked up, or their street or their address. You know, what's the property valued at? You know, what's the owner's name? What's the mailing address? What's the property address? You know, how many bedrooms? That's all
But the
public
fact, if I
information.
may, but the fact that MDOT has entered into discussions or at least sent a notice regarding an interest in taking all or part of the property, that is not accessible under current law as interpreted by MDOT.
Correct.
Okay, that cleared it up. Thank you, Mr. Chairman.
Certainly. Delegate Hill?
Thank you, Mr. Chair. So Delegate Carr, I want to make sure, because it's gone back and forth a lot. So just clarify if I've got this right. Unless it's for commercial purposes, this bill would allow for me to petition under the PIA, MDOT, and say, what is the notice you sent out and what are the households? They would then give me a list of addresses without identifying the owners, the email addresses, or anything else, but I can see, to Delegate Kaiser's point, exactly which blocks of which neighborhoods got it, to give me a perspective on who is potentially targeted for the eminent domain breach. And that's all I have. It's a picture. If I want more information, I can use public records to get all the specificity, but it's not their names. It's simply these lots or these addresses. Is that correct?
Thanks for that question, Delegate. So under this bill, the MDOT would provide the actual letter or the notice. And that notice does contain the, you know, that all the same information that's available through SDAT. You know, name of the property owner, which might be a person or an LLC, and mailing address of the property, you know, maybe property account number. That's the information that's in a letter like this that would be revealed under this bill.
See, that's interesting because I saw where it says in the original statute, a custodian shall deny inspection of the part of a distribution list that identifies email address and telephone number. You're saying this is to be not considered, this is going to be an exception to that rule?
So we're saying that a letter sent out by MDOT is not a distribution list.
Okay.
So it wouldn't fall under that provision.
And so to the issue of privacy and negotiations to sell property and the other issues that were raised, why is it not sufficient to ask for what properties got it? And I can look at that list, see that I'm on it. I mean, I should already know because I got a notice. Why do we, okay, I'm trying to get why we're getting it. And then my other question is, it says not for commercial use, and that's probably in the statute. What's the penalty if I ask for it, say it's not for commercial use, but then I sell it to, you know, somebody who's selling whatever they're trying to sell and they start targeting these people for that product? What's the penalty for using it for commercial use?
I believe Lindsay Council said.
I'm going to look into that and get back.
Yeah.
Okay.
Okay. I'm going to hold the bill.
Okay.
I think there's been a very valuable discussion, but I think there are too many unanswered questions for us to go before the full committee. So we will consider this bill at next week's session, next week's meeting, and I will be involved with Lindsay and keep those who are interested informed about what we've learned. We will inform you prior to the meeting. Okay, let's go back to the first bill then on the list, House Bill 13, procurement, discriminatory hiring practices, debarment. Also Delegate Carr. No respite for the weary. Please explain, and hopefully everyone has in front of them the bill with a proposed amendment. Council.
As introduced, requires that a person be debarred for 5 years from entering into a contract with the state following the issuance of an administrative order by the U.S. Department of Labor that finds that the person has violated a federal executive order by engaging in discriminatory hiring practices in the state. The amendment that hopefully everyone has, rather than debarring a person for 5 years, the amendment debars the person until the person has demonstrated to the Commission on Civil Rights that the person has established and will carry out personnel and employment policies in compliance with the provisions of the executive order.
So instead of a certain period of time, regardless of what may have been done to cure the problem. This amended bill would provide that, would actually in effect put the burden on the company, the person, to demonstrate to the Commission on Civil Rights that may have established will carry out the policies in compliance with a federal order.
Right. And there was a prior introduction on this bill, but it was in-house rules last year, and there is no fiscal impact.
Delegate Kaiser, followed by Delegate Chisholm and Hill.
Thank you, Mr. Chair. And thank you. It was my question during the hearing that I believe prompted this amendment. And the reason I mentioned it at all at that time was that it was referenced that that we're using the federal government's standards here, but the federal government allows companies to, in a sense, fix themselves and prove that they're doing it right. So certainly, why shouldn't we do that same thing here in the state of Maryland? So again, whether we agree with the civil rights violation or not, the idea is they've had one, and it is allowing someone to fix the problem. So I hope people appreciate that amendment. So thank you.
Thank you. Delegate Chisholm, followed by Delegate Hill.
Thank you, Mr. Chairman. I did notice the amendment this afternoon or earlier this morning as well. It looks like it addressed both the builders or the transportation builders and the asphalt community. They said they didn't want to take a position until the bill was amended. Did you speak to both of them, Delegate Carr, to see what their position is now that it has been amended?
I have not. No, I had not had any communication with them other than seeing their testimony. I don't believe that they have a reason to be concerned about the bill. And I think the message is, if you want to continue doing business with the state of Maryland, don't discriminate against your employees.
Thank you, Delegate.
Delegate Hill, I'm sorry. Followed
Yeah,
by
so
Delegate Fliego.
question on the amendment. So I think I get the idea that if people make right, you want them to be continue to have access to doing business with the state. But what I'm concerned about is so often the state continues to do business with the same bad actors who make promises, and there is no real penalty here. I mean, theoretically, you could prove to the commission that you've corrected your stuff within weeks, and you're not barred from doing anything. And I guess what I'm wondering is, why isn't there within this amendment the opportunity, or would you be objecting to the commission having the authority to say that they're clear, or somebody saying, but there's a minimum amount of time before they're going to be eligible again, that they're not eligible for the next bid option that comes out, but they can sit out one round or something like that. There's no real penalty here. So it's a question about the amendment.
Isn't the penalty determined by the federal government? Because that's where the initiating action was filed. And that we are simply saying, while you are under a federal mandate, that's not the precise word, you cannot. So it's really, the decision-making is federal, and we are simply saying, you can't do business with us as long as you are still found in violation by the federal government.
So we're saying you have to cure it, but there's no additional penalty once it's cured, bygones.
Yes, the penalties.
Right, it's a slap on the wrist from our standpoint. You don't have to sit out one round before you come back in or anything. Okay, that's how you guys, okay?
Well, you are sitting out until you cure the problem. So it's not that they're being untouched by the state government. You cannot participate while the federal government, until the federal government, could be 5 years or less or more, until the federal government releases you from its penalty.
Okay, so my question, I guess, to Lindsay is, do we have any sense of what that looks like? So can we, do you know if minimally, do people tend to correct these things and get an okay by the commission within weeks or months, or is it usually years and they end up losing one round? Can we say a minimum of one round, or until such time you correct the injury and are found to have corrected it, the lesser of the two.
I don't think the one round language would work because that's a sort of amorphous term of, how often do procurements happen? And it would vary greatly depending on the unit that's doing procurement and the company that's seeking contracts with the state. So I think if you did want to put a specific time frame on it, it would need to be months or years. That would be very specific. But I have no real idea of how long it would take someone to cure in this way. The Commission on Civil Rights would presumably need to adopt regulations on how a person would show the commission that they have adopted the policies necessary to enter into contracts again. I also just wanted to clarify that the way that debarment works for procurement contracts is the Attorney General can institute proceedings to debar a person by filing an administrative complaint with the Board of Public Works. So some affirmative action has to take place to debar a company in the first place, because otherwise, how would a unit ever know that the person is debarred?
All right, thank you.
That's under existing law.
Yes, that's existing law now. And that would apply to this provision in the bill.
Delegate Saliga.
Thank you. I have a couple questions. Delegate Hill said the same bad actors. Is this a big problem? I mean, how can you quantify for us how many times the Commission on Civil Rights has it violated the personnel and employment policies? Maryland contractors. I mean, is this a big problem? Do we have scores of bad actors doing this? Is it a one-off? Have you quantified this?
Is that a question for the sponsor?
Yes, or Lindsay, anybody who has the answer.
Okay, yeah, thank you, Delegate, for that question. So I refer you back to my written testimony. I included in that written testimony a article from the Baltimore Sun about a company that was found guilty in Maryland of discriminating against their Maryland employees and was required to pay $6.6 million in restitution to their African-American employees who were denied hiring, advancement, promotion. So I think to those people who were denied, it was a very big problem.
Yeah, I certainly would agree. Were they state contractors?
So the name of the
with the
company is
state?
called Enterprise Rent-A-Car of Baltimore, LLC. And so they were receiving federal contracts. They do also get money from the state. But I think the point of the bill is to provide an additional disincentive for companies to, not discriminate. So they'd be at risk at losing state money contracts.
Certainly, we, don't want people who discriminate to, be eligible. I like the impetus of the direction, but my other question is, debarred is a term, that sounds, I again understand where your original bill was going. I like Delegate Kaiser's amendment, but would a better word be suspended? I mean, does debarred then include some other hurdles? I mean, if the federal government says, okay, you've demonstrated that you've corrected these policies and, paid for whatever violations you've done, you may now be eligible to bid on state contracts. How would you feel about using a different word like suspended? Because debarred, seems, I don't know, maybe Lindsay could answer that. Or what about the terminology?
I think the term debarred was used because there are other actions for which a company can be debarred from entering into state contracts. And so to be consistent with those other provisions. And those are things like bribery or tax evasion type of things that would get a company debarred.
Okay, all right. That, yeah, I mean, the enterprise thing, I do recall you talking about that in your testimony was horrific. Is that a one-off or is this, do we have a lot of problems with that? That would be, something that we could probably use that information to see how widespread this problem is. Thank you.
I would suggest that it's what is the appropriate penalty for any such violation, and that our job is what is the appropriate penalty, and for one or however many violations there are. We wouldn't want to not act if there are only a handful of instances, if we feel that debarment, the term of art that is used in other contracts, similar cases under our state law, is the appropriate penalty. Delegate Hill.
I'm sorry, another question. Unfortunately, I was in another hearing when this bill was heard, but the Maryland Asphalt Association had asked, is there in our current statute, and if not, would there be anything in this bill that would give an opportunity for appeal process to the debarment?
There is an opportunity for a hearing, and the amendment is also an opportunity to cure.
You're saying that under existing law, before anyone is debarred from a contract with the state, they can
They have
request a hearing.
Yep, they're entitled to a hearing before the Board of Public Works.
Okay. Is there readiness to vote?
I have a question.
Certainly.
Sorry.
Delegate Kipke.
So then that would preclude what I worry about as politics, and the Board of Public Works is some of the most theatrical politics that there is. I like where the amendment is going. I think that's good. What I wonder though is, does then this preclude entity from taking their appeal to a courtroom with a judge, so that we don't have so much politics in what might be, a major decision for, you bring up a huge company. It could be a small company too. It could be any company. Would the entity be able to take this to court?
I would assume, to the extent that any decision of the Board of Public Works can be appealed, such a debarment decision can be appealed.
Sure of that.
This is just following the hearing procedures under the Administrative Procedure Act, which gives an opportunity for appeal as well to court.
Okay. Thank you.
Is there any objection to proceeding with a vote? I need a motion then. On the amendment.
Move favorable.
Okay. All those in favor of,
What? Wait, sorry, Mr.
Certainly.
Chairman.
yes.
The state has something for contract appeals currently. I forget what they're called. I'm curious if that's, do you know what I'm talking about, Lindsay?
You mean if you're filing an exception to the award of a procurement contract?
Yes.
Mhm.
So that it's like, it handles the disputes of bidders, basically, right?
Yep.
Do they have a role in something like this?
That's
I think that it might be more appropriate that they handle this than the Board of Public Works. Let me just cut to the chase.
That's really more on a sort of unit by unit basis. If you are either a bidder or offer on a contract that's unsuccessful for some reason, you can file a complaint with the unit, or if there's a successful bidder who becomes a contractor, has a contract dispute with the unit. This is a sort of more overarching because it would bar a company from entering into a contract with any unit of state government.
Okay. All right. Thank you.
So the motion has been made and seconded on the amendment.
Delegate Shillelagh has her hand up.
Sorry, Delegate Slager.
Thank you. What is the process for if a Maryland company is found to have been engaged in discriminatory hiring practices? What happens right now? Like, without it, if it's, I'm assuming if they're, they're governed by Maryland. So someone was Enterprise, the company that you're talking about, Delegate Carr. Were they brought up on, I don't know the right terminology here, were they brought up on charges for violating hiring practices within the state of Maryland? And if that is the case, what happens to a Maryland company that's found to do this, who's, in the Maryland procurement system?
Is that a question for me?
Yeah, somebody, I don't know, you or Lindsay.
So I guess in the case of Enterprise, in 2016, they were charged by the feds. They were a federal contractor. They were getting federal money. They were charged by the feds for discrimination. And then, they went through the whole process with the feds, and the feds, I guess, found them guilty. And in 2019, 3 years later, came down with their ruling. And then, a punishment and a fine. You got to pay $6.6 million in restitution. And so we're just following, if the feds found a Maryland company guilty of discriminating in Maryland, we're just going to follow what happened with the feds.
But what's the process within Maryland? Maybe Lindsay, you would know if.
Yep. There would be a complaint can be filed with the Commission on Civil Rights, and the Commission may assess civil penalties. These are for violations of the anti-discrimination and employment laws. If the respondent has not been adjudicated to have committed any prior discriminatory act, an amount not exceeding $500, the respondent has been adjudicated to have committed one other discriminatory act during the 5-year period ending on the date of the filing of the current charge, an amount not exceeding $1,000. And if the respondent has been adjudicated to have committed 2 or more discriminatory acts during the 7-year period ending on the date of the filing of the current charge, an amount not exceeding $2,500.
And is there any language in there limiting their ability to bid on state contracts?
There is not, though the debarment language does cover some provisions of the labor employment article. Let me pull those up real quick. So you can be debarred for willfully or knowingly violating the provisions on equal pay for equal work, the provisions on wages and hours, and provisions on a wage payment and collection, as well as occupational safety and health provisions of the labor employment article. So to the extent that the violation would fall under any of those provisions, that you could be debarred from that.
And what's the debarment penalty for that? Is there a length of time, or do they say until you've corrected the problem, or?
I don't believe there is any length of time. It is just they were debarred.
Permanently? Is that what that means?
Yeah, I believe so.
Huh, okay. So it's interesting. I wonder why they didn't also bring this Enterprise case through the Maryland system as well. Nobody do you think it's just because nobody filed it there?
If it didn't involve wages, if it was some other it was discriminatory hiring practice, for example, as opposed to unequal payment of existing employees, then it might not have fallen under that provision.
Okay, thank you.
Okay. Is there any objection? Any objection to the amendment? Chair
Mr. Chairman.
sees none. Oh,
Mr. Chair, I'm sorry.
sorry.
I'm just curious if we've talked, I am supportive of the concept, but I'm worried, have we talked to the Board of Public Works? Have we talked to the commission that the amendment references? I'm looking in the the testimony here, first it's the bill as originally introduced. We're not hearing from those entities. So I'm just curious, have we reached out to them to discuss this at all? Because we're bringing them into it, and I support the direction that we're going. I just want to make sure that it's the appropriate entity for the appeal. And, you know, maybe there could be some feedback from them as to the best way to go here. I don't know, Lindsay, do you have any feedback on my comments?
I don't know. But if I can go back a second to Delegate Schlegel's question, there is a language here about determining the period of debarment from the Board of Public Works. So they could put a period on it. It's not specified in statute what that period would be. Presumably it's based on how bad the infraction was.
Severity.
But under this bill, it would be identical to that of well, you would be eligible to be released, to be undebarred, to be able to, again, participate once the federal government had said you were okay. The Department of Labor had said you were no longer acting in a discriminatory manner. And then it would be a pro forma action by the Commission on Civil Rights.
It could be, unless the commission decided that it had different standards than the Secretary of Labor for the federal government.
I'm not sure.
So I would just like to request that we speak to, you know, folks in the know who understand this better than I think we do,
No.
as to what's the appropriate venue for an appeal. The Board of Public Works sometimes is just ridiculous, depending on the characters that get there. And we all have people that we can think of when I say that out loud. But I don't mean it disrespectfully, truly. It's just, you know, I think we need to have the fairest environment for this type of thing. So I'm just curious if we could maybe reach out to, you know, what I think is it Lenore Hughes? Is that her name?
Glendora.
Glendora, yeah.
Hughes, yes.
Maybe get her feedback on this. Like, what's the best way to do it so that we're doing it? The BPW may be right. I don't know, but let's just maybe get her feedback as the best way to handle this, the most functional way.
That's valid. That's
Mr.
valid.
Chairman, can we vote on the amendment though, in the meantime? Can we move the bill forward or not?
Well,
Amendment's not related to the BPW issue.
well, the civil rights, Ms. Hughes may say this is not the best way to word it. I think at this stage of the session, and given the sense of the committee, we're not doing the bill any harm by holding it.
Mr. Chair, I just wanted some clarity. Being we are going to hold the bill, Delegate Hill made a point earlier about, you know, bad actors in the if there were any penalties, and I know that Lindsay spoke to this, I believe, briefly, of saying if there are multiple violations of this, something can occur or would happen to the entity. Is that correct, Lindsay? Does that kind of speak to what Delegate Hill's issue was, of saying like, okay, they'll correct it and they'll be like, okay, you can go ahead and make application for the next bid or whatever, but nothing really happening? But were you making the statement that if there are multiple infractions, then a monetary slap on the hand would happen?
That's in reference to the civil penalties for discrimination that are under current law. The frequency with which you find yourself in violation of these provisions increases the civil penalty that's assessed. So the Commission on Civil Rights, as the way the amendment is drafted now, would be tasked with determining whether or not the company has adopted the employment practices and policies necessary to cure whatever it is that they had been doing wrong in the first place. So it's really left to the Commission to determine whether or not what they are proposing as their cure is adequate. And presumably, if there were multiple violations, that would require a little bit more of a a hurdle to show that there's been a cure, as opposed to if there had been one violation.
Okay, thank you.
And I think there's a question in my mind whether this is a pro forma, that all that's needed is to show that the Federal Department of Labor has said you're no longer in violation, or you've addressed, done what we required you to do. So that's another question that needs to be answered. And also there's a State Board of Contract Appeals, whether that is an alternative to the Board of Public Works, that perhaps there's less theatrics there. All right, so we will return to this issue next week. Third and last is House Bill 167, Commission to establish a Maryland Women Veterans Memorial. Council.
Yes, okay. The bill establishes the commission to establish a Maryland Women Veterans Memorial to provide recommendations for the funding, design, construction, and placement of an appropriate memorial dedicated to Maryland women veterans. The Department of Veterans Affairs is staffing the commission. It's got all the usual provisions on compensation for members. The commission must submit a preliminary report on its findings and recommendations to the Governor and General Assembly February 1st, 2023, and a final report September 30th, 2023. There's Delegate Bagnall. I know that she's working on an amendment for the bill, which I can defer to the delegate to describe.
Delegate Bagnall.
Certainly. Lindsay raised a very valid concern about the commission being staffed in an election year. So we are looking at altering the appointments by the governor to appointments by the commission, the Veterans Affairs Commission, the Secretary of the Veterans Affairs Commission, and also to define the women veterans organizations. The only reason that we don't have that language yet is because we have a call into Dana Burrell, who is sort of the expert on the appropriate organizations that would want a seat on the commission, and she's collating that list right now. She contacted me yesterday and said that she is working with the Deputy Secretary, Legislative Liaison together, and she's hoping to have it today. But we just didn't have it in time for the subcommittee, and I apologize.
Okay, so we are awaiting amendments on this bill, but just to make sure there are no other questions about the bill, so that we can move forward on it, if that's the will of the committee next week. Are there any other questions regarding this bill? Okay, so we will put this bill on hold as well. All right, so we're helping to make it a short 1 o'clock meeting on Friday. We're doing our part. All right, we are.
I'll get that language to you as quickly as possible.
Certainly, thank you. All right, we stand adjourned. Thank you all. Very positive discussion. Thank you all very much.